People are going to be coming in, but I think we'll start it up. We are on time. Good morning, everybody, and thanks for joining us here on this, I guess you could say, very timely issue that a lot of us are facing regarding remote work and telework. And I assume everybody here is here to make sure their policies are buttoned up and maybe brainstorm and consider some other ideas to make things, to improve some of your processes. Just so everyone's aware, there's we're going to have a lot of information to cover today, and we'll be moving through the slides fairly quickly. But an e-blast went out shortly before the webinar with a copy of the presentation materials, along with information on how to request HRCI or MCLE credits. And then a second e-blast will be sent following this presentation with a link to the recording of this webinar. And that e-blast includes links to our labor and employment law blog, as well as our firm's COVID-19 resource hub that you can refer to, which some of that contains some of this information we'll go over today as well. But in today's webinar, we're also going to be using the chat or the raise hands functions. So by now, I assume everyone's somewhat familiar with Zoom, and that will be enabled. So, and if you have a question we can address, on the fly during the presentation, I'll try to do that. But more likely, we'll be going through as many of those as we can following the presentation. I'll leave a bit of time for that. So again, make sure you have that enabled. And please enter your questions in the Q&A queue, and we will try to reserve some time at the end to answer some of those. So without further ado, this is an issue, obviously, that's been, thrust upon a lot of us due to COVID-19 and the shelter-in-place orders. Nearly every company that could work remotely across the nation was required to do that. A lot of people and companies had to make sort of, last-minute adjustments and changes. And a lot of those weren't exactly made correctly. Sorry, hold on one second. I'm going to share my screen here. Give me one moment. You can see my two youngest daughters there. Okay. One moment. Okay. There's my contact information if you have any questions specific that you want to address after the fact, or you don't want the group to address necessarily. But there, I wanted to start about the inherent problems with remote work, which we'll also refer to as telecommuting. And from a wage and hour perspective, employers are required to compensate employees for all time during which the employee is under the control of the employee, whether or not the employee is required to work. And the FLSA and California law require companies to pay for all hours worked, and that includes overtime, obviously. It includes also work that is not pre-authorized. So this term, some of you may be familiar with, work not requested but suffered or permitted to work is work time and must be paid. So just by, for instance, having a policy that says employees are not supposed to work, or we didn't specifically ask this employee to work during this time. That's not a defense to a wage claim necessarily, because it's very broadly defined as any work that is suffered or permitted to be done. And another issue that's inherent with telecommuting issues is this de minimis rule, which doesn't apply in California. Now, with the de minimis rule, it does apply to federal statutes. So for the FLSA, which is the labor code, the federal version of the California Labor Code. But in there is a de minimis rule that applies. And what that is essentially that insubstantial or insignificant periods of time beyond the scheduled working hours may be disregarded and do not need to be compensated for those times. So like really quick, donning and doffing issues or login times, or a line that builds up at when you're checking in to clock in or something like that. If it takes a few seconds or even a few minutes in some instances on the federal rule, that's considered de minimis. You don't need to capture it and pay for it. In California, that's obviously not the case, as I mentioned. That all time, even if it's consistently and regularly required, will be considered compensable time. And from a remote perspective, again, the trick is how do you capture all that this employee is doing when they're completely outside of the workplace, and a lot of companies, perhaps yourself included, are set up to have a more kind of on-site with a supervisor there, more accountability. You have, clock-in records and things of that nature that you can use to confirm, time records that employee keeps. But again, none of that is there. And it's tricky when employees, are at their home computers and they have access to work whenever they want, so there's that, and something else, there's been a huge uptick in remote work, obviously through the pandemic. So, but even after that, USA Today did a poll and they found out that, the large majority of companies are working this into their game plan, into their future business model. And, especially, larger businesses, and to the extent smaller businesses, can accommodate it. But, and a lot of workforces are kind of demanding it now, right? A lot of talent is demanding remote type of accommodations. So, huge, the exact percentages vary depending on what study you look at. But a lot of, reports are saying that we're going to see a huge significant shift. And this might be the lasting business legacy of the pandemic, is that this has shifted the workforce to a remote situation. So today we're going to talk, in addition to, the pandemic stuff we're familiar with, now a lot of companies are using this as an opportunity to, batten down the hatch and institute policies for a longer period. In some instances, setting up telecommuting agreements with their employees versus just the shelter in place, emergency type situation. But going back to this slide, again, the de minimis rule doesn't apply, but the California employers, as many of you know, were also required to track the start and end times of all work, including lunch breaks, start and end have lunch breaks, not just that the specific amount of lunch break was taken, you have to include the specific start and end times of that. Obviously, again, when someone's at home, how do you track that? And also meetings, you have Zoom meetings. A lot of times, this is for better or worse, a lot of meetings are happening after hours now, right? Because of the convenience of Zoom and other types of remote, communication devices and that people are using. Also, pre and post shift work, that all needs to be recorded. So a lot of the question is, well, what about if someone responds to an email or, a call that happens after hours? We'll talk about that. And again, there hasn't been a change in the wage order, the wage laws or wage orders or anything like that. So we need to make sure that this is, the trick is to, somehow square our practices with the existing law. We're also going to talk about some legislation that's pending, because there is very little law on this issue, specifically dealing with remote or telework arrangements. There's not much guidance or accommodation for it, but there might be some. That's the silver lining here. We'll talk about later. And just to mention here, COVID-19 related workplace lawsuits are now among the most common. And it could be any type of association with that. There's sometimes companies that have paid hazard pay that didn't work that into the regular rate. There's all sorts of and a lot of it is just timekeeping issues. We're going to talk about reimbursement issues as well, which are becoming quite popular. But you're seeing a shift away from a lot of the interpersonnel lawsuits we're familiar with, which are the discrimination, harassment, retaliation, and we're seeing a lot more of these wage and hour type claims. So with exempt employees, it's a lot more simple for obvious reasons, right? We don't need to track their time worked. We don't need to record their meal or rest breaks. So a remote situation for exempt employees is a little easier. However, the reimbursement, workers' compensation issues, and some other ergonomics concerns will still apply. And again, we'll talk more about those later. But again, this is the general rule for tracking of non-exempt employees. And this is where it gets more dicey. But the DOL has recently issued some interpretive rules that did, the Department of Labor, this is the federal, agency, they issued some rules that gave some guidance on the telecommuting type arrangement. And the rule states that employers are required to exercise control to ensure that work is not performed that they do not wish to be performed. Okay, so it's one thing to say we didn't authorize it, we didn't suffer permit it, but there has to be some proof, and we're going to talk about that, some sort of effort to make sure that work is not being performed that you don't wish to be performed at the times you don't wish it to be performed. The general rule is that failing to pay for unreported work that the employer did not authorize and has no way of knowing was being done does not violate the law. But if the employer knows about the work, even if they didn't ask for it to be done, they must pay for the work. So this deals with actual and constructive knowledge. So there's actual knowledge, which is what they, what the employer reports. There's also constructive knowledge, and a wage and hour claim can be brought on the back of just testimonial evidence, right? Where someone says, and I'm going to go to the next slide because this ties into that. But looking at this last thing, where for instance, project assignment. So if a project is assigned at the end of a business day and told that it needs to be returned, or completed by the next morning, and the employee finishes the project, and that would take a certain amount of time, and they had very little or no time reported work during that time period. Okay, so that could be considered constructive knowledge that that work was being completed off the clock. So again, that's if a company didn't have a policy in place or a way for that to be reported or captured, that could be problematic, and that could trigger minimum wage violations. It could trigger potential overtime violations, and then in addition to the host of derivative claims, waiting time penalties, all of those fun things. And if it's done on a large scale basis, it can result in a class action liability potentially. So with, again, regards to non-exempt employees, some key issues to be aware of are time zone issues. So this is, a lot of times employees are going to be working, permanently, sometimes on a temporary basis, outside of California. And, so if calls are scheduled or emails are sent or meetings, then outside of their schedule and the schedule they're working, perhaps in the Midwest or somewhere else, right? That's going to push them into overtime situation that maybe wasn't intended by the employer. So that's another thing that companies don't usually need to be concerned of, because everyone in the facility is usually in the same time zone. Work schedules, I'll make sure those are clearly delineated, but be mindful of what those look like when sending emails and communicating. And again, I mentioned assignment expectations, when a project is delivered, and, time expectations. The key to that is train managers to be clear with regards to, assignment expectations and when the deadlines are expected to be. And I'm also going to share, kind of a checklist of what should be included on the minimum of what should be included on a type of an agreement or a telecommuting policy with an employee. So the most critical piece to the timekeeping element is obviously having a reasonable time reporting system that is designed and capable of capturing all this time worked. And it's preferable to have a timekeeping software that permits actual time recorded, and that doesn't round. There's some case law recently that really rounding policies are very difficult, can be difficult to support, even if they're neutral. So even if they round, just shave a few minutes, or if they always round up or always round down, you know, if the ultimate effect of that policy isn't neutral, even though it's facially neutral, it can be unlawful and lead to class liability. So be mindful of that. Sometimes ADP and Paychex give an option just to check that, but it's generally wise to have timekeeping software that records the actual time recorded. And, you know, sometimes employees are permitted to write their own time in. The problem there, and again, it's not necessarily a problem, but the potentially problematic issue is employees will tend to write in the exact same time every day, you know, even though there might be some variations. And it's as a general rule of thumb, it's good to see slight variation in the time, because it lends to support the veracity of the time records themselves. Because as a matter of fact, humans aren't robots, and they don't typically start exactly on the minute and end exactly on the minute all the time. So a little variation isn't the worst thing in that regard. But again, so let employees either write in their own time, but we'll talk about what happens when an employee does, because if your policy is to, you know, handwrite something in, you're going to see less likely minute specific type, you know, entries. It'll say 8 a.m., you know, to whatever, 8 hours later. In the policy, it's important to ensure that employees are not, or policy or practice, to ensure that employees are not discouraged or prevented from using the system and from capturing all time actually worked. You know, so nothing's worse than when I, you know, have a case and I have to see a policy that, you know, says you can only work during a certain time, you can only record during a certain time period. I mean, that's kind of a nightmare scenario. So make sure, again, the policy specifically says that all time needs to be adequately captured and recorded. The time system needs to record and allow a first and second meal break. So this is something a lot of software, and I'm gonna show you one later on, but actually only allows this, the way it's actually structured only allows for one meal break. That's problematic, obviously, for employees that work over 10 hours and are entitled to, you know, a second break. So the you know, waiver discussion aside, you know, if the software itself doesn't permit that to be added, you have a big issue, potentially a class issue. So and again, make sure the timekeeping software has that capacity. And it's always helpful to permit employees to make corrections and let them be aware of that. They can adjust and make their corrections. And, you know, this, if they are rounding, again, a lot of this is about, you know, again, making sure we're adequately capturing time, making sure that employees are correctly, you know, compensated. But in addition, one day it might become an evidence issue for you, you know, and so it's important to make sure that you know, we have as much evidence as possible to support our policies. And, you know, the fact that the software permits the employees to adjust or make corrections shows that they weren't locked into something. All these things kind of help defend these types of claims. Another very helpful defense to wage and hour claims is if a company that limits access to the company's software after hours. So if it's only permitted during those working times and they can't actually perform work, there's a strong assumption that there's no constructive knowledge, because no work could actually be performed, right? So there's some limitations there and some potential problems, but that's been very helpful for some clients I've seen. Okay, and with regards to the actual written timekeeping policy, again, and I'm going to reiterate it because it's very important. First and foremost, that employees must accurately record all work performed. They need to be, you know, told that and reminded, and that needs to be in writing. No off the clock work permitted. It's not even permitted, right? That's it. If someone does, you know, perform work off the clock, they did it against the company policy and instruction. You know, this is somewhat more discretionary, but, you know, to the extent employees should be seeking work for overtime, presumably companies don't want a bunch of unauthorized overtime, you know, make sure that is authorized beforehand. However, if overtime is ever worked, even if it wasn't authorized because it was suffered or permitted to work, it needs to be paid. So never should, you know, companies, it's not advisable to, you know, adjust or redact time or whatnot because it wasn't authorized. If it was worked, it needs to be paid. That doesn't, limit a company from disciplining someone for performing off-clock work, because that was, again, that's a violation of company policy potentially. So that's, and again, trying to make sure in the policy that all the time worked. And you could, it might even be helpful to list emailing, texting, and, using whatever specific software you use, that needs to be captured and recorded. And in the policy, to state the consequences of violating the policy. Again, that they will be paid for the work, but it will be disciplined and potentially fired for violating the policy. And as always, with all policies, swift and consistent enforcement should, quickly curb repeat violations, as well as prevent allegations of selective enforcement later on down the road. Just as important as having the written policy is training supervisors to make sure that they're not discouraging employees from recording all hours worked or encouraging them from working to work off the clock, again, directly or constructively. Supervisors need to be trained in that regard. In addition, for the written timekeeping policy, sometimes employees, they're used to telecommuting, they're comfortable working from home, and then suddenly they're told to come into work, and you have a problem there because now they can start their work site. So it's clear to delineate that on-site work might still be required, for whatever reason. Training or meetings may still be required. And again, that needs to be compensated. And so after the written policy, again, still in the realm of tracking time for non-exempt employees, the employee verification, and we've talked about this before for those of you who've been on some of our other webinars, this being a very critical piece to wage and hour claims, and generally to a way to kind of put a bow on the, a great policy, an airtight policy here, which is, at the end of each pay period or work week, that employees are given the opportunity and they're required to verify their full schedule they've entered. They usually enter on a daily basis. And then at the end of the pay period, they have the opportunity to go through and are told specifically in writing every single week, a little blurb to confirm this captures all the time they worked. You can even summarize the policy there. And then they're, can make corrections, and then they click, some sort of verification button, or, that they certify that this is correct. And again, make sure that whatever type of work is properly coded. And, sometimes otherwise, if you don't have this, it's easy for errors to be buried, and they don't come up until you have a class action or a POGA action, and everyone's looking at this and you see there's some sort of, systemic problem with the time recording software or with, the policy. This really helps kind of shore that up. And here is an example of that. And I'm not going to call this an ideal example. The reason being is I mentioned, the fact that you want to have a second time period. This doesn't seem to give that option. You have your AM core, this is start and stop times, and the PM core, start and stop times there with the regular hours worked. You can see again the difficulty here where you have, this 10 a.m. to 11:30, and how that could be problematic. It would tend to show some sort of rounding, which is generally unlawful in a lot of contexts in California. But that aside, this is kind of the verification you have, and you'd have kind of a blurb or statement in this area in the section 3 that would talk about those issues I mentioned previously. That no off-the-clock work is permitted. It's good to kind of summarize the policy again right there. And also, well, we'll talk about meal and rest breaks in a moment, but so after that's all done, in addition, it's good to have the supervisors, review so especially for meal break violations, because those need to be, again, the start and stop times, those need to be recorded. So as always, this isn't just for telecommuting employees, to verify and look at those, why they're, why they're off, why they're short, why they were late, why they were interrupted, make sure that those are followed up if that's the case. because, as you know, premiums still need to be paid even for remote employees. If they record a late lunch, it's advisable those be recorded, but you can also confirm in writing why those were missed, right? Why those were late. They might say they chose to do it, and that's fine. But you can see this creates a hassle for employers to do it. But that is the best practice, is to make sure that each one is accounted for, each violation is accounted for. And if it turns out it was work related, a premium should be paid. And if needs be, restructuring of the position, if it's a repeat issue, so that's no longer a problem, and that's a possibility as well. So again, all that stays the same for telecommuting employees. And confirm if you need to that overtime that was worked, that was reported, that was authorized. But and this is something we see far too often, is that managers will ask, or at least there's testimony that manager asked the employee to change their time records, right? Because they shouldn't have worked that, or they willingly took their break late, so they need to put it down that way so the record looks clean. That's not the way to handle it. Make sure the records are always accurate, and that no requests for fixes are made by managers in that regard, unless a fix is in place. In fact, sometimes employees, they start working again and they forget to clock in or check in. Hopefully that's caught during their own verification time period. But if not, that can be technically a fix. Okay, so mentioned, meal and rest breaks here. And this is what a lot of companies struggle with, is you have an employees working from home and they're outside of they're outside of the normal, view of the employer, and you can't see them taking their breaks. All you can do is tell them to take their breaks, right? And you're going to give them work, and there's a lot of, it's viewed as kind of an on your honor system, because rest breaks aren't recorded, right? But technically, again, because there hasn't been any so far, there hasn't been any adjustment for telecommuting in the regards to breaks. The employers are still required to provide remote workers with the ability to take meal and rest breaks. So again, that can come to work break. It might be wise to say, if an employee, to clarify in the telecommuting relationship, that if employees' workload is such, because of the nature of that the employer can't see them, that they report immediately rest break violations, or not violations, but if their workload was such they weren't able to take their break, that's reported to HR, their supervisor. Because again, there's no other witnesses, and when these turn into class actions, it becomes an evidentiary issue, and there's no witnesses, so that helps and hurts in some instances. So the importance of having an airtight policies is critical in telecommuting circumstances, even more so than when for on-site employees. Again, the policy should mention that they're to report any violations or missed meal breaks, or interrupted or late, and include have the opportunity to take the breaks in the weekly or bi-weekly time verification. So kind of going back to that verification here, it's good to have a blurb, that during this time period, employees, were given the opportunity to take their meal and rest breaks. So again, a lot of that looks like what you're familiar with, and there's not a lot of, other than trying to accommodate the remote circumstance, there's not a lot of deviation from what we're all familiar with. But there is some pending legislation. There's two, I believe, bills specifically we're going to talk about that could create some more flexibility for remote workers. And let's look at those. So AB 1028, which is called the Telework Flexibility Act of 2021, and AB 230, which is called the Workplace Flexibility Act of, give me 1 second. Make sure I have the function here so I'm not missing any. Okay, perfect. These were both introduced earlier this year, January and February, respectively. And what they both actually, have a lot of significant overlap and address most of the same issues. But essentially, these would allow remote employees to individually agree to a 10-hour workday within a 40-hour work week with no obligation to pay overtime if worked within those time limits. So a lot of you are familiar with alternative work week schedules, right? These are 10-4s, and other types of variations that an employee can agree to other than just the 5/8. So in this circumstance, you look down, this doesn't need to be authorized by 2/3 voting of employees in a work unit. So typically when you're doing an alternative work week schedule, as many of you may know, there needs to be essentially a vote in place for that to break the paradigm of the 8 hours a day. And that can happen, and then but it's only after that's a fairly complicated process. And again, needs to be filed with the LWDA. If this passes, these can be done on an individual basis. So again, any hour worked up to that 10 hours, so it's essentially be kind of a 410, then that would not be considered overtime, provided the employee agrees to it, and provided it's, here it says, that it's in writing and it contains all the specific information, and that'll be detailed, once this thing comes out, and it's signed by the employee. Again, then that's a little easier. I think the biggest piece though here is with regards to meal and rest breaks, because again, if these bills ultimately become law, then the remote employees can choose when to take their meal and rest periods during the workday, if they're not already scheduled by the employer. And again, it gets around a lot of some of these bigger issues we've been talking about, because it truly puts it all in their discretion, which it kind of already is. But this would, put that in, codify that reality we're already experiencing. And the employer must notify the employees of their right to take their breaks when they want to at the start of the, when this relationship is initially set up. And if an employer doesn't provide that notification that employees can take their meal and rest breaks when they want, then the employer is to pay 1 additional hour of pay for each day that the employer fails to provide the notice. So again, this is going to get around a lot of the wage and hour allegations you're going to see, because when these class action claims come in for these remote situations, guaranteed you're going to see a meal and rest break violation. And as you can see at the bottom here, this excludes meal and rest break penalty under PAGA from a PAGA claim if this arrangement's in place. So that's a huge benefit to employers and would limit, liability in that regard. As some of you may painfully be aware of the, PAGA. PAGA is, for those of you who aren't aware, is essentially kind of a quasi class action that the state allows employees to bring a claim against the employer on behalf of the state and to get all sorts of penalties that the labor commissioner can normally get. And the bill would require all the alleged violations that occurred in a period beginning with March 19th, 2020 and lasting until January 1st, 2022, or until the declared end of COVID-19 state emergency issued by the governor, whichever is earlier. So, I mean, we're basically there for that. So, but again, that's a huge, you don't get too many limited liability gifts as an employer. This is one of the few in California. So again, this isn't the law yet, but keep your ear to the track on this one, because it'll have some good implications for those of you who are using telecommuting arrangements. Okay, so this is almost, if not a bigger issue than the timekeeping, which is business expenses and reimbursements for remote workers. So generally speaking, as you all are aware, employer must provide reasonable reimbursement for all necessary work expenditures. So whenever work is required due to shelter, even when the work is required for shelter in place order. So I had some clients who, this was a confusing issue for them, right? Because some of this was the first time a lot of companies were having a remote arrangement. And so there's kind of this, we're in this together mentality because of the pandemic, but in reality, the company still had to provide a lot of the tools and equipment and all the expenditures necessary for work. It wasn't to be split, between the employee. And we're gonna, to keep the office open, we're gonna, everyone's gonna have to button down a little bit here. There was a lot of that mentality, and again, not that it wasn't justified, but it, potentially created some risk with regards to this reimbursement expense, because even with a shelter-in-place order, the company is obliged to pay for those, those payments. And I haven't really seen a lot of agency kind of going after companies for that initial time period. I think there was a little bit of, grace period for companies to get used to, the situation. But again, we're seeing a lot of class actions now that are based on some of these violations. So here's the kind of 3 key questions to ask when determining whether a reimbursement is necessary for expenses. Because again, what's a business expense, right? I mean, I'm wearing clothes today. Does the company to pay for these? My car that came here to work, does that need to be reimbursed? So these are the general rules. Is the expense necessary? How much is reasonable to spend? And how should this expense be reimbursed? There's been some lawsuits and issues as a cell phone plans, internet. We have received more clarity, through the sad experience of some employers, that we're getting a little more understanding about what this looks like. But cell phone plans, right? So again, with remote situations, this becomes almost the biggest issue, because inherent with needing to stay in contact is a way to stay in contact, usually through a cell phone and the internet. And there's 2 ways to provide reimbursements for these. Obviously, in a remote situation, it's hard to imagine a place where internet wouldn't be required, right? So it's going to be considered almost invariably a necessary expenditure that requires some sort of reimbursement. The question then becomes, what percentage do we reimburse for this, right? These employees are also watching Netflix, their kids are on school using this internet, right? And so why should I have to pay anything for it? And in addition, a lot of times these cell phone plans, internet plans, they're not, you can use it a tiny bit or a ton, and they pay the exact same. So, some employers have made that argument, and ultimately the case have come back and said, doesn't matter. You still need to reimburse a reasonable percentage required for work. So there you go, reasonable percentage, right? So there's 2 ways to do this. There's through a stipend or actual reimbursement using receipts when you do that. Obviously, it's going to be a way more complicated process if you base it on the actual expenditure. The rule now is usually to provide some sort of stipend for that. And the one court has held that a cell phone alone, a cell phone plan may be enough. You don't have to provide internet and a cell phone plan, because with technology, you usually have a cell phone plan, you can tether that into some sort of Wi-Fi connection that way. So that's helpful, because again, sometimes the question is, do you pay for both? And with regards to a stipend, which tends to be kind of the easier way to do this because it requires far less administrative oversight, is to include a specific stipend. And people always say, what's the magic number? I see anywhere from 20. Sometimes I see a full reimbursement for cell phone plans up to $100. But it's in that range, usually closer to the $20 what I see. But at your own peril to see where a court's going to come down on some of these things, because it will often come into effect of what is required for your specific workplace. And but the way to kind of not get around this, but a way to kind of make this more bulletproof, a stipend situation, is to have a policy that says that if this stipend in any way doesn't cover the actual expenditure, that the employee puts the onus on the employee to submit receipts in that circumstance, or to contact HR, so that the proper reasonable reimbursement can be provided. And in most instances, the stipend is just accepted and considered fine. But that's, again, that policy, that little caveat is pretty critical to defenses in some instances. Okay, so we also have furniture, right? We're all sitting on chairs. A lot of you are probably at home right now. You have a desk, computers, printers, what about those? What needs to be provided there? So generally, if telecommuting is permitted based on the employee's request and not mandated, the employee can usually use their own personal office equipment. But again, it's important to ensure this is voluntary, so that there's an actual workplace available for them to come in if they wanted to, right? It's one thing to say this is voluntary; it's something to actually make it voluntary. So just be aware of that. And then written policy would obviously include that in the telecommuting arrangement on this issue would generally include something like the company doesn't accept responsibility for damages or repairs to the employees on equipment, that any company equipment is used only for company purposes. Obviously, if any company materials or equipment are taken, that those, you keep a record of that kind of thing, and that there's always be some indication that be, returned upon termination. But there's also these, exhaustible type supplies that will always need to be provided by the employer, that other than the chairs or the computer itself, like the paper, pens, and ink cartridges, stuff like that. To the extent those are being used and required to be used, then those need to be provided by the company, even if it's just permitted, right? If mandated, it's different. The employer must provide those things. So if it has to be done, then obviously the company has to provide that opportunity and provide those reimbursements. And again, keep that record of the equipment that's being used and that's been issued out to the employees. The other issue, I'd say, I'm not going to say less common, but workers' compensation safety issues. So as many of you know, in general, employee injuries are compensable under workers' compensation law if it arises out of and in the course of employment and their duties. And that's true regardless of where the injury occurs. So in the work environment, the home is the workplace. And so injuries that occur at home are potentially covered under workers' compensation. This obviously creates some concern because how do you determine whether the work-related injury occurred during work hours or was related to work? And this often leads to some, fraud or misclassification problems, where a non-work related injury that occurs at homes where remote employees are recorded or, deemed, compensable workplace. So because of that, when possible and appropriate, and it's important to include this in your telecommuting policy, that you have the ability to conduct periodic checks in employees' home offices to identify and eliminate work area safety hazards, because that could help, again, defend some of these things. Obviously, most importantly, make sure that the employees are safe and protected. A lot of this seems a little bit, treating them as infants almost, checking on the safety of their homes. But it's good to have that right to do that and to make sure, again, to the extent you're aware of a risk, that's covered and fixed, because it's their workplace, that their home, they've deemed it as an alternative workplace site, right? And so employers are responsible within reason to ensure that telecommuters are safe or in a safe work environment during that time period. And a lot of these issues you're going to get will be, ergonomic issues. So again, make sure there's clarity in the telecommuting arrangement that to the extent, someone needs an ergonomic chair or something like that, or something to, prevent what's called a repetitive injury versus a specific injury, right? There's a slip and fall, or there's also just repeated use, through a keyboard that doesn't work right, in the work office, you usually have, mid to large size companies, you usually have some sort of ergonomic expert. Communicate with your workers' compensation carrier. I know it's the bottom here, but that is, very important, because there's a lot of resources that your workers' compensation carrier might have in this regard with regards to ergonomics and safety and workplace reporting, and safety checks, and again, coverage issues, because you don't want to have a situation where the company authorized something that falls outside your workers' comp coverage plan. So again, it's important to coordinate with your workers' compensation carrier those types of issues, and get what they have, because that's their business, what they're dealing with. And these are some of the greatest hits you want to see in a written safety policy, inside the telecommuting agreement rather. And that's again that the employee has a duty to designate a safe and secure remote workplace free from hazards, and that complies with OSHA standards. Again, this almost seems a little bit like you're treating them like children, but you want to make sure this is written that proper lighting and ventilation, and it must adhere to company safety policies, and that the company, you want to make sure that you've given the company the right to access the premises, given enough notice to assess safety and security issues, and that the employee is still obligated to report in a timely manner any work-related injuries or illnesses. The company's workers' compensation insurance does not cover injuries that occur that aren't related to work, essentially. And again, from third parties or from them, that's clearly delineated there in the policy. And in addition, injuries that work outside of the scheduled work hours. That's one of the best determinants of what's a covered claim or what's not, right? If it occurred, not when the company system was turned off, they couldn't be doing work, and there's a record the injury occurred then, clearly it wouldn't be covered. And yeah, the other two are pretty self-explanatory, but again, that give the employee that opportunity and put the onus on them to contact the manager or the human resources if there's any questions about the safety of the alternative work site. And throughout this, we've talked a lot about specific items to include into your telecommuting agreement. Here's some other important ones that didn't really fall under the rubric of anything else we've talked about so far. But to include a statement that the agreement doesn't affect the at-will employment agreement, obviously, that whenever you send something this is agreement, it's important to make sure that this doesn't in any way affect the at-will employment agreement, change that or alter it. And the telecommuting policy is not guaranteed. This isn't an inherent right with the employment. This is something we've agreed to for this time period, and that it may be withdrawn by the company in its sole and absolute discretion, with or without cause. It's also important to include the same performance and productivity standards apply. If you see problems, it might be necessary, obviously, to make sure the company has the ability to revoke that agreement, to withdraw it, and to have the employee work back in site, because it doesn't work for everybody. So employees do better in more accountable environment. And it's also important to clarify that any travel to and from the actual company work site is considered normal commute and is not compensable or subject to reimbursement. I mentioned earlier, it's easy for employees, and we see this sometimes where employees, because they're work from home, that kind of becomes their permanent work site. So if they have to go into the office for anything, you might get a reimbursement request. Well, you want to make sure you stem that and make sure it doesn't become a situation. That time traveling to work under wage and hour law, that's not considered normal commute, isn't compensable time. And just because we're having you come into the office and maybe you don't do that regularly, it doesn't convert that into compensable time. Again, it's reimbursement or wage and hour issues. And also, you got to think about if the employee is required to travel anywhere, you want it to the best extent possible to clarify what that will look like. How does mileage reimbursement work now? If that employee is required to go to different vendors or different clients or customers or make sales calls, from their home, make sure that the mileage reimbursement situation, because they should still be, it's an alternative work site, so the mileage would be from their home potentially. So there's some positions that are not amenable to telecommuting. So what's important is, again, when you're seeing this big shift in across the board, if anyone does their work behind a computer, you're seeing a lot of telecommuting options now. So there might be some positions that you just don't want them, you need them there, or you want them, there's some value to them being on site, right? And you might see a situation where a group of employees or employees specifically feels like they're being targeted because they're not given this opportunity, right? So because of that, it's important to list in your job description that attendance is an essential function of the job. Again, often when it comes to accommodation requests, or whether the employer is making up a convenient justification, after the fact, courts and everything else, they'll tend to go back and look at the job description because that was created before there was a dispute, right? So again, if the company wants that to be an on-site position, it's safest to put that in the job description, and to otherwise be consistent. Because if exceptions are made and there's too much there, then it adds, obviously, the question as to whether that is attendance is an essential qualification of this job. Obviously, you always have to do the ADA and otherwise, reasonable accommodation evaluation to see, but that applies regardless of a general telecommuting relationship, because as many of you may know, remote work might be a reasonable accommodation for some positions. That the employees, provided they can perform their essential functions of their job with or without reasonable accommodation. So here's a case that came out in the Sixth Circuit, and I'm not going to get too into the weeds on it, but this, and again, you should have these materials, and I think if you're not, you'll be getting them after the presentation. But the takeaway here is there was essentially an attorney that questioned the veracity of the employer's claim that this had to be in-person presence during work hours, and they would provide telecommuting. And the court essentially said that if it was in the job description, it would have been more conducive to the employer's position. So again, add that. That's my little scare tactic case right there. Another big issue we have are some remote employees that work in different states, or in many cases, different countries. So the question is, okay, well, we're familiar with California law, for better or worse. Do I now need to learn a different state law? What applies? Workers' comp issues, right? So generally, if an employee is working in another state, there are circumstances where the other state laws could apply. That is especially true in the state and the permanent relocation circumstance, right? Where an employee is permanently relocating on a remote basis. Then you're definitely, certainly going to face, at least required to analyze, and it'll often include, analysis of that state's specific laws, because different states have different choice of law, evaluations. Both states might claim some sort of regulation of the employee, but it's important to be aware of that, because that employee could potentially file in a state you had no clue of, and suddenly you're defending a case in Nebraska you knew nothing about, right? Especially in the case of a permanent relocation, the company may be obliged to follow new state and local tax obligations, right? And California employers may be required to withhold state income tax for the state from which remote workers live and perform their job duties. In addition, workers' compensation in other states. So chances are, if you have a California only policy, employees that are working outside of California, that might not be covered. Again, the reason why you want to talk to your adjuster on that, your claims administrator, for your workers' comp policy. And it might also require you to add coverage for that specific state. So again, before you say yes to someone doing this, to an employee working permanently outside of the state, it's important to make sure all these boxes have been checked. Additionally, wage and hour laws of other states might apply. Usually that's a good thing, right? Because, it's rare that you're going to see an issue where, other states have a lower standard or a higher standard than California. So usually if you're abiding by California, generally speaking, you should be somewhat all right. But there are instances where specific issues or requirements are required in other states, that don't apply to California. So because of all these things, again, and because of the wage and hour law is usually, in a lot of states, it's a state by state function. Workers' comp is a state issue. It's not, not usually a federal concern. So because of that, it'll probably be important to speak with a wage and hour attorney about the laws of the state, or a tax professional with regards to tax implications associated with the other states, so you don't find yourself in a problem where, again, you've tacked on a bunch of liability, or you have tax concerns and audits that you weren't expecting. Okay. So we don't have a ton of time here, but let's see. So if anyone has any questions, I see I did receive, it looks like a question here about are there any laws that prohibit public employees relocation out of state this past year because they are paid with public money? So I'm not specifically aware of any public employees, but generally speaking, a lot of what we're talking about today deals with the private sector. There's not too many distinctions between the two, but I'm not aware of a specific caveat with regards to public employees in that regard. But we can if you want to reach out to me independently, we can look into that for you. Okay, and then someone said they haven't received the e-blast with the slide deck. I think Ramona said that she will. Oh, everyone check your spam filters, by the way. I even had issues getting some of the materials today. So if you didn't get anything, I want to make sure everyone gets their their credits for this, and that you have these materials. Make sure, check your spam filter. If it's not there, reach out to Ramona, and we will definitely make sure that you get everything that you need. In addition, your materials will include some of our other upcoming presentations and webinars, and I'll just kind of briefly go through some of those here. But be aware of those. Make sure you register. Again, you can reach out to Ramona if you'd like to attend some of these, and a lot of these are pretty topical as well. But again, I always am concerned I'm missing one of my, a raised hand or something. But I think it looks like there's not too many other questions. But again, I would feel free to chime in if you have anything. If not, this concludes the general presentation here. Thank you all for participating. Good luck in setting up or rolling out these telecommuting arrangements on a wider spread and more permanent basis. And again, thanks for attending today and your participation and your attention. Thank you.